Well, as I tell you, losses the problems in that area. But the kind of
just problems in the area, we see that. But also we understand the significance of the point which you have made, which is a very significant point for constitutional democracy, that ultimately the party is supreme.
Yes.
And legislators get there into the House or the Parliament or the Legislative Assembly on the mandate of the party, what the party means to the people.
Correct.
Therefore, you are really elected as a representative of the party. Your behavior must be governed by what the party dictates.
Right.
And a group of legislators, whether you are 1/3 or 1/10 or even 75%,
that's right,
cannot be really determinative of the wishes of the parties. You can alter that position if the party authorizes you. You leave the party.
Correct.
So far, so good. I mean, that's a very significant point which you have made. But
I understand.
The next point. I mean, what's the consequence?
I will, but I know.
Which you are really telling us that, look, the facts stare you in the face. Now why go to the speaker?
Yes, that's what my submission is. What is it that the speaker is going to do in this?
It could be twofold. One, as you say, well, the speaker himself cannot be trusted as an impartial arbiter.
I withdraw that, because we are talking about the constitutional position.
Right. The second would be where the facts are so clear.
Yeah.
Then you take the decision which the speaker ought to have decided that there is only one and one conclusion.
That's right.
That, Mr. Sibal, honestly, that is a matter of disquiet for speaking for myself. I mean, should the court be taking into that? Entering into that area? That's an area of.
Lordships have been persuaded in the past. I hope to persuade you in the future. That's right.
There are very serious ramifications. Just as you know the ramifications.
I will address Lordships.
The ramifications which you have referred to for constitutional democracy, if individual legislators start bucking the party discipline, there are very serious ramifications if we start taking over these functions.
No, what happened was. In one particular case, which is the Constitution bench, where they said that this illegality cannot be continued even for a day. So we will take the decision. Because they are occupying the post of the minister. This cannot continue even for a day. I will not send it back. We will.
Right or wrong, this is the system which we have now assumed to ourselves as we the people. And when the courts try and breach the system, it's a very...
No, I understand.
That's what is worrying us.
Quite frankly, a constitutional court should be worried, because if you create this as a precedent, it can happen in other situations as well, and that not be a good precedent. But I am not disputing that. Please, I'm not... I know the limitations of a constitutional court. I know that, but what has happened in this case, unfortunately, is that this has happened because of a judicial order.
Possibly, your argument would be, until the speaker is deciding, no trust vote. Let them take a decision first, and then, because the trust vote...
Because everything helped there after that happened because of this order.
But therefore, if you have to restore the situation as it stands immediately before the interim order of this court, we can restore it by saying that, well, the speaker has to take a case as of that date.
Yes.
Had they incurred a disqualification.
Yes.
But it would be very difficult for us to take over that function.
I don't mind, let that deputy speaker decide. I have no problem with that. That's what happened in...
Therefore, which deputy speaker?
The speaker, who was denied the right to continue with the disqualification. This has happened in the other case.
So then we restore a putative state of affairs.
Yes, your lordships have done that.
Overtaken by events.
In Nabam Rebia, your lordships have done exactly that. Because when I argued this before the Constitution bench then, I said, what is happening is you let things happen, and then you will tell me later that we can't reverse it. He said, no, we will reverse it.
Sibal, then you support Nabam Rebia's course of action when it suits you. And when Nabam Rebia is creating a problem, you wanted to...
No, that's because there are two different issues in Nabam Rebia, I'm sorry, you can't put that argument.
No, we're not at all.
There are two different issues. In fact, I was wondering when your lordships are going to decide to refer it to 7, because this is a real problem. That's intrinsically at the heart of the matter, which is why I said you take it up as a preliminary submission, because ultimately this can only be decided. Number one, your lordships have now noticed that Gugavale was appointed as the whip from Assam. If your lordships agree with me as a proposition of law that the whips cannot be appointed in this fashion, ultimately the speaker once that government is formed on the 3rd, recognizes Gagavale, right, Mullahs? And then I am issued, our legislators are issued a notice for disqualification on the 8th of July. If your lordships agrees with my proposition of law that whips cannot be appointed in this fashion, then our notices should be quashed by this court.
Subsequent notices.
You are notice.
Under 21B or 21A.
Yes. Against us. Notices against us.
Correct.
Yes. 21B.
21B.
Yes.
But they are virtually non-issue, right?
No, it's not a non-issue. There's a notice of disqualification against me because they say Gogavale gave a whip.
You are right.
Right. So, it's a live issue.
Legislators whip.
Correct.
Not the political parties.
Yes, legislators whip. So, therefore, my request to your lordships is that notice for disqualification must be struck down by your lordship. If your lordships, of course, agree that you cannot appoint a whip from outside.
But that's the direct challenge also.
Yes, we've challenged that. I've challenged that, Mullahs. Now, one more point, Mullahs. Your lordships, Mullahs, in September, when a whole petition was argued that the election commission should not proceed, your lordship said no stay. Fine, Mullahs, no stay. We went back. Mullahs, what happened was we thought, and this is my, Mullahs, we interpreted the order to mean that the proceedings before the commission should go on. Fine, Mullahs, let them go on. The problem arose that we told the commission, if you take this test of organization and representation in the legislature, you necessarily will have to include 38 or 39. And therefore, if you take that into account, your outcome, your result may be that they get the symbol. But that very matter is pending before the Supreme Court about the disqualification of these 39. So please stay your hands and let the Supreme Court decide. Now, I personally feel, Mullahs, that was not it was not antithetical to your lordships. After all, the Election Commission has also to decide in accordance with law. The result was, this is again the sad part of it, the result was, the commission says, I am not going to bother about the organization. These 39 members are majority, therefore they get the symbol. In fact, your lordship's order was misused. No, I'm not asking, Mullahs. I'm really saying the commission said, the High Court said, Supreme Court has said no stay, therefore they have to decide.
That needs to be tested in those proceedings, no?
No, that's not. But kindly see the consequences, Mullahs. Kindly see how we are hurt. Mullahs, I'm not. Your lordship's passed, Mullahs, rightly so, according to me. That let the commission, but the commission doesn't have to, can't disregard basic principles that you are giving symbol to a party on the strength of those 39 whose disqualifications are pending.
And that issue is pending before this.
That's pending. And I said to them, please stay your hands. They said, no, but Supreme Court has said that we have to go on. That's how the symbol is given. See that injustice caused to us. I just make the point, Mullahs, and not go further.
Is it, according to you, there was no information in the possession of the EC to show that there are rival groups and it has to be satisfied?
Yes. Now, Mullahs, the petition.
Can you just rephrase your submission, Mr. Sibal, again on this point?
Mullahs, I'm saying, Mullahs, the jurisdiction of the commission will commence when the commission has in its possession information on which it is satisfied that there are two rival factions within a political party.
Right. And in this case, what is the...
Now, Mullahs, kindly see. Therefore, in the context of this 10th schedule, Mullahs, now just that proposition. In the context of the 10th schedule, the only way you can get a symbol is when there are two rival factions within the party. It has nothing to do with the 10th schedule.
No, this has nothing to do with the 10th schedule.
Correct.
Right. So, Mullahs, there has to be a faction emerging. Take, for example, Mullahs, majority of the people in the 10th schedule are with Thackeray. Let's assume all 55 are with Thackeray. Then also para 15 Mullahs can be invoked.
By somebody making an application.
Because 15, para 15 refers to the party.
That's right. So, Mullahs, the split
refers to
correct. The split has to take,
I'm
agreeing, Mullahs, I'm saying exactly. Right. That split has to take place within the party.
Right.
That split did not take place on 21st June or immediately thereafter. Never took place. A petition is filed on the 19th of July.
Correct.
Just note that, Mullahs.
19th of July.
19th of July.
19th July, absolutely.
Correct.
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings. Now, what do you have here? No time, no place, no date is given 18 July, no summons. I suppose this is a meeting of the Pratinidhi Sabha of the Shiv Sena. So it must be known to everybody where the meeting is going to be. Summons must be sent like we sent to them, right? What they do is they give a translation of the minutes of the Pratinidhi Sabha. And in the minutes, they show some resolutions have been passed. Minutes, as your lordship will know, is after the meeting. It can't be before the meeting, right? It has to be after the meeting. Page 10. Again, minutes. Again, when it is held, what time is it held, where it is held. Yes, they say it happened, it is held in Bombay. This petition is filed on 19 July. He says that the petitioner was elected as the senior leader and senior Mukhya Neta. The minutes are dated 27 July. This is what they filed. So 19 July, they could not have known what would happen on 27 July. And that also minutes of meeting. These are the only two documents with the commission. That's why I read paragraph 15. These are the two documents with the commission in respect of to prove that there are two factions arising. And second document was submitted during the course of hearing, but be that, I don't want to go into that. I'm just only interpreting 15. This is the documents in their possession, information on the basis of which Election Commission is satisfied that there are two factions within the party. So minutes of meeting. So these are the two documents with the commission. Now if you read paragraph 15, this represents two factions in the party, the minutes of meeting. That's how the Election Commission got jurisdiction, according to them. And this is a final order. This is kindly just look at it. I can understand if the commission says lead evidence. I can understand, please prove your case. On this basis, a final order is passed, which is the subject matter of challenge in the other proceeding. That's how they got the symbol. So what does the governor do? What does the Election Commission do? And this is the evidence. And then we have to, we must ensure, we must trust that all institutional authorities function in accordance with the law. And if this kind of manipulation takes place, in the processes of institutional decision making, where we go, where we will go, I don't know. Now, this act, the fact that you did not attend the meeting, the fact that you wrote this letter, the fact that you appointed the chief whip, you 45 people or whoever, whether 40 or 45 at the moment, we're not on that you are members of the Legislative Assembly, you have appointed your own chief whip, you say that you are no longer the whip, is all, there is no, as far as I am concerned, this is per se illegal. This doesn't emanate from the party. He cannot, members of the legislature cannot pass such a resolution, cannot defy the whip, cannot remove the whip. So the 40 odd members sitting in Assam convert themselves into the party and decide to remove everybody. So therefore, let's put it in simple terms. In any assembly, 10 people can get together and remove the chief whip. And then they can go to the opposite party and with the numbers game that is going on, they can they can actually destabilize the government and have their own chief minister. This is the outcome if this is upheld if it is held to be valid. If such an exercise is held to be valid, the outcome is that you can remove, an elected government can be removed any time depending on the arithmetic.
To put it on the flip side, therefore, Mr. Sibal, your contention would be then, if this outcome has to be lawfully achieved of removing the chief whip or the group leader, then what is the course of action to be followed according to you?
You have to go to the party, call a meeting of the party. Call a meeting of the party, or you merge.
Party would mean the national executive, or what would it mean?
You have to call the national executive, the Pratinidhi Sabha, the general body, the Pratinidhi Sabha, not the Karyakarani. That's 13 members. The Pratinidhi Sabha has 262 odd members. Point is, they have never been to the party.
Of course, the only chink in that submission, we must put it to you straight so that you can deal with it, is that was not the process which was originally followed when the chief whip or the group leader was nominated, unless we also postulate that when the group leader and the chief whip were originally nominated, Uddhav Thackerey was acting as the party.
Yes, because he was neither a member of the council nor was he the chief minister. He was nothing. He is the Paks Pramukh under the constitution.
One thing, as Brother Justice Shah pointed out very clearly, it's obvious that the appointment and the nomination of the group leader and the chief whip was made at a meeting of the MLAs. Power to nominate a group leader and the chief whip is delegated to Shri Uddhav Thackerey, but there is a, so to speak, an anointment of them at the meeting of the MLAs. So the only way really that the two can be reconciled is by postulating that in that sense, at the original meeting, Mr. Uddhav Thackerey was the party. He was, whether you like it or not, he was the party. It was not a meeting of the national executive. It was not a meeting of the plenary of the party. But he was really the whole and soul, because he was not an elected member at that point of time at all.
He was the president of the party.
He was the president?
Paks Pramukh.
He was the Paksha Pramukh.
Yes. And Dan Malads, I just want to make one statement. I stand here not for this case. I may lose it, I may win it. That's another matter. But I stand here, Malads, for the protection of what is so close to our heart. Institutional integrity,